In the spring of 1854, a newspaper editor named Sherman Booth rode on horseback through the streets of Milwaukee, shouting at the top of his lungs, "Freemen, to the rescue! Slave catchers are in our midst. Be at the courthouse at 2 o'clock." By that evening, several thousand people had gathered outside the Milwaukee County Jail. Booth gave a speech. The crowd surged forward. They battered down the jail doors with a wooden beam. And Joshua Glover, a man who had been born enslaved in Missouri, who had escaped to Wisconsin 2 years earlier, who had been dragged from his home by federal marshals the night before, walked out of that jail a free man. He made it to Canada. He was never recaptured. What followed from that single night, the arrest, the trials, the defiance of an entire state, and a Supreme Court confrontation that reached all the way to the edge of the Civil War, became one of the most extraordinary legal battles in American history. This is the story of a law so unjust that a free state refused to obey, of a Supreme Court that said they had to, and of a state Supreme Court that looked at that ruling and filed it in the trash. To understand what happened in Wisconsin, you have to understand the law that started it. The original Fugitive Slave Act of 1793 required the return of escaped slaves to their owner. By the 1840s, it had been largely ignored across the northern states, which had passed their own personal liberty laws, making enforcement difficult or impossible. Slave owners were furious, and in 1850, as part of a broader political compromise designed to hold the fragile Union together, Congress passed a new version, strengthened, federally enforced, and designed specifically to close the loopholes the northern states had exploited. The 1850s Fugitive Slave Act was something new and deeply alarming. It required not just federal officers, but all American citizens in free states, in cities that had abolished slavery for decades, to assist in the capture and return of escaped slaves. Refusing to help was a federal crime. Harboring an escaped slave was a federal crime. Even obstructing an arrest was a federal crime, punishable by a $1,000 fine and 6 months in prison. And the process was rigged by design. Rather than trials before a judge and jury, cases were heard by federal commissioners. Officers paid $5 when they ruled in favor of the accused, and $10 when they ruled in favor of the slave owner. The person accused of being a fugitive slave was not permitted to testify on their own behalf. The slave owner's sworn statement was, by itself, sufficient to have a person seized and transported south, even if they had been free their entire lives. In northern states, the reaction was outrage. In Wisconsin, a state that had entered the Union in 1848 as ambiguously free, that had attracted thousands of German immigrants who had fled European tyranny and arrived with deep convictions about human liberty. The Fugitive Slave Act was not merely unpopular, it was treated as a moral abomination and a direct affront to the state's sovereignty. Wisconsin passed its own personal liberty law, severely hampering federal enforcement within its borders. The state's courts made clear they were skeptical of federal jurisdiction over these cases, and the newspaper editors and abolitionists and ordinary citizens of Milwaukee were building towards the moment when theory would become action. That moment arrived on a cold night in March 1854. Joshua Glover had been enslaved on a farm in St. Louis, Missouri, owned by a man named Ben-Ami Garland. In 1852, Glover escaped. He made his way north to Wisconsin, to the small town of Racine, where he found work at a sawmill and began building a life. He had been free for 2 years. On the night of March 10th, 1854, Glover was in his cabin playing cards with 2 friends. Federal Marshal Charles Cotton arrived with a party of men, including Garland himself, who had traveled from Missouri, and a warrant issued under the Fugitive Slave Act. They did not knock, they broke down the door and seized Glover in a violent struggle. His head was cut, he was beaten, shackled, and dragged to the Milwaukee County Jail, 50 miles away. The word spread fast. Sherman Booth, editor of the Milwaukee Free Democrat, one of the most prominent abolitionist newspapers in the state, heard of the arrest and responded the way he always responded, loudly and in public. He rode through the city, calling people to the courthouse. By evening, the crowd was several thousand strong. Booth gave his speech, and the mob that answered him battered down the jail door and carried Joshua Glover into freedom. Garland went back to Missouri empty-handed. Glover made it to Canada and was never heard from in the United States again. 3 days later, federal marshals arrested Sherman Booth. The legal battle that followed Booth's arrest was not a single case. It was a 5-year war between two court systems. A war that exposed, more clearly than any other episode before the Civil War, the impossibility of holding together a union in which half the states treated human bondage as a foundation of their economy, and the other half had decided that they would not be complicit in it. In May 1854, Booth petitioned Associate Justice Abram Smith of the Wisconsin Supreme Court for a writ of habeas corpus, in order to free him on the grounds that the law under which he was being held was unconstitutional. Justice Smith agreed. He issued the writ and ordered U.S. Marshal Stephen Ableman to release Booth. The marshal complied. Ableman then appealed to the full Wisconsin Supreme Court, asking the court to overturn Smith's decision. The full court reviewed the case, and not only upheld Smith's, but went further, declaring the Fugitive Slave Act of 1850 unconstitutional in its entirety. The federal government appealed to the United States Supreme Court. While that appeal was pending, federal prosecutors tried Booth in the U.S. District Court in Wisconsin, a separate case, convicted him of violating the Fugitive Slave Act, and sentenced him to 1 month in prison and a $1,000 fine. Booth petitioned the Wisconsin Supreme Court again. The Wisconsin Supreme Court issued another writ of habeas corpus, freed him again, and again declared the Fugitive Slave Act unconstitutional. By this point, the situation had become a direct collision between two sovereign legal systems, each claiming the final word. The Wisconsin courts were asserting that state judges could review the constitutionality of federal laws, and, if they found them wanting, could free federal prisoners by writ of habeas corpus. The federal government was asserting that no state court had any such authority, that federal law was supreme, that federal custody was federal custody, and that a state writ of habeas corpus could not reach inside a federal case. U.S. Marshal Stephen Ableman filed a writ of error with the United States Supreme Court. The Wisconsin Supreme Court's response was extraordinary. It refused to file the record of its proceedings with the United States Supreme Court. It refused to acknowledge the federal court's jurisdiction, and it issued an order declaring, in effect, that the United States Supreme Court had no authority to review Wisconsin's court decision. The Wisconsin Supreme Court was telling the highest court in the United States, "We do not recognize your power here." On March 7, 1859, Chief Justice Roger Brooke Taney, the man who had written the Dred Scott decision just 2 years earlier, ruling that Black Americans had no rights the white men were bound to respect, delivered the unanimous opinion of the United States Supreme Court in Ableman v. Booth. It was, as a matter of constitutional law, a thorough and logically comprehensive opinion. Taney grounded his ruling in the Supreme Court clause of the Constitution, which declares that the Constitution and federal laws are the supreme law of the land, binding on every court of every state. He argued that the entire structure of the American government depended on federal courts having the final word on questions of federal law. That if each state could declare federal law unconstitutional and free federal prisoners at will, there would be no federal government at all, only 50-odd sovereignties pulling in different directions. He was not wrong about the constitutional logic. The argument for federal supremacy was sound. The problem? The enormous, agonizing, morally catastrophic problem was the law it was being used to enforce. Taney upheld the constitutionality of the Fugitive Slave Act in full. He ruled that state courts had no authority to interfere with federal custody by issuing writs of habeas corpus. He ruled that Wisconsin's courts had acted outside their jurisdiction from the beginning, and he warned that if states were permitted to nullify federal law, the Union itself could not survive. The decision was unanimous. 9 justices, not a single dissent. The mandate went to Wisconsin. Wisconsin refused to file it. The Wisconsin Supreme Court simply declined to enter the U.S. Supreme Court's mandate into its records. It did not comply. It did not acknowledge the ruling. One justice wrote that the Wisconsin's court stood on its own ground and would not be bound by a federal opinion it regarded as wrong. It was legally an act of nullification, the doctrine that southern states had long claimed as their right to reject federal law they opposed, now deployed by a northern free state against a federal law protecting slavery. The irony was not lost on anyone watching. Sherman Booth remained a cause in Wisconsin politics for years. The case radicalized by the state's Liberal Party, which ran on an explicitly anti-Fugitive Slave Act platform in the 1856 state election, and swept both houses of the legislature. State Senate candidates were required to pledge support for the Wisconsin Supreme Court's position Booth himself became a symbol of: resistance, of consciousness, of a state that had drawn a line. He was ultimately pardoned for his federal conviction by President James Buchanan in the final days of his administration. In January 1861, 3 months before the first shots of the Civil War were fired at Fort Sumter, the constitutional question at the heart of Ableman versus Booth, who has the final word, the states or the federal government, was one of the deepest fractures running through the American Republic in 1859. Taney answered it in favor of federal supremacy, but he answered it in a case about slavery, using constitutional logic that was correct on its face to enforce a law that was monstrous in its purpose. The southern states would spend the next 18 months citing state sovereignty as their justification for secession, the same doctrine Wisconsin had used to resist the Fugitive Slave Act. The argument that a state could nullify federal authority, could simply refuse to comply with a ruling it disagreed with, could assert its own sovereignty against the power of the federal government, that argument did not respect political boundaries. It was available to anyone who needed it. What Ableman v. Booth revealed is something about the nature of constitutional law that is easy to forget. The same legal principles can be used to produce opposite outcomes depending on what law they were applied to. Federal supremacy, argued in 1859 to the enforcement of the Fugitive Slave Act, would be argued again in 1865 to enforce the 13th Amendment abolishing slavery. State sovereignty, claimed by Wisconsin to protect a free man, was claimed by the Confederacy to protect the institution that enslaved him. The law is not about justice. The law is the arena in which the fight for justice is fought. And in 1859, the fight was just beginning.